Hi, my name is Claire Smith. I'm a second-year student here at UND. First, excuse me, when I'm up here, I kind of seem to have a small case of the plague, so let's try to ignore that, please. Our next speaker is Kristine Paranica. Kristine has been the director of the Conflict Resolution Center here at UND since 1999. She provides training in transformative mediation, conflict management, and other processes. She is nationally recognized as a transformative mediator. Additionally, Kristine is an adjunct professor here at the School of Law, where she teaches alternative dispute resolution. Kristine serves on North Dakota's Joint Committee on ADR, chairing the subcommittee on family mediation. She recently penned the protocol and rule for the statewide family mediation pilot project, as well as the ethics code. She also serves on the UND Council on Campus Climate and the President's Advisory Council on Women. Kristine will be speaking today about the effect intimate partner violence can have on family mediation practices and how to best address those problems in future mediation practices in the state of North Dakota. This is a huge concern, as often the most dangerous time period for victims of intimate partner violence comes at or soon after the point of separation from their partners. One illustration of this is the story of Kelly. Kelly was a mother of two from Wadena, Minnesota, who had left her abusive husband, but who still had to drop off and pick up their children from her ex-husband's home in order to satisfy the requirements of her custody agreement. One day when Kelly went to go pick up her children, she never made it back out of the house. She was killed because she was forced to comply with a custody agreement that did not reflect the true nature of their family dynamic and did not take into consideration the violent relationship between the two spouses. Kelly had been my foster sister for a short period of time when I was still very young. I wonder now if her life could have been saved if she had been able to go through a family mediation process that would have been able to meet the unique needs and circumstances that are presented by couples with a history of intimate partner violence. Please welcome Kristine as she speaks about how attorneys and mediators should proceed on the behalf of families who find themselves in these situations.
Clicker. So thanks for that nice introduction. I had a couple of tough acts to follow, and I think it's an interesting way to start and to move in and out of considering domestic violence from different perspectives, and to have a personal story from somebody who experienced not only child sexual abuse but also domestic violence in her lifetime, and where it's brought her now is a really powerful way to start. And then to move into legal implications and how do you create a system that has laws that protect victims of domestic violence, and how difficult it is and how late it seems for a country like China developing such laws and rules. And yet, when we hear stories from victims today, we recognize that we haven't come as far as we should have in 40-some years of having laws and having protection. And it's important to consider the different contexts that we run into domestic violence with, and probably the best thing that I think we have going for us today in this country and in our state is that the focus for quite some time now has been on prevention. And as we hear these stories, we recognize that that's where it's at, right? I started in my professional career. When you go to law school, it's a professional degree, and we consider ourselves professionals in day one. We're told that we're professionals on day one of our first year of law school. And in my second year, the law clinic had its first project to take victims of domestic violence to court to get their protection orders. And there was a feisty lawyer named Ronnie Rosenberg who headed up that program in the late 1980s, and I was the first law student to work in that program and work with domestic violence victims and work with the CVIC and other organizations at that time, and got to see kind of firsthand what that was like, but also to see the stereotypes that existed and exist to a lesser degree now, but are still there. You know, the stereotypes around, well, did she ask for it? Did she deserve it? Is there, how bad is it really? Is there evidence, physical evidence of abuse? So going back to what Robin was talking about, and only if there's physical evidence of assault do we take it seriously. And from there I went to be a criminal prosecutor in Bismarck, and I was the only female state's attorney at the time, and inherited all of the sexual assault, including assault against children and domestic violence cases on my first day on the job, pretty much. Also a gender stereotype, I'll just have you say, because the men didn't want to touch those cases with the 10-foot pole, because they're hard, right? They're gut-wrenching, they're hard, they're emotional cases. And over the 7 years that I worked there, it was, you have to be blind to not recognize the pattern. That when a child experiences sexual or physical violence in the home, it starts a cycle of either being potentially a victim of that sort of thing as they grow up, or to be an offender of those things as they grow up. And so there's always this thread for me, the domestic violence connection, even though I've worked in different places since then. I've come back to Grand Forks and have been at the center now for about 13 years. That it continues to be an issue that's been part of my life because of my experience in prosecuting those cases and going through that when I came to mediation practice eventually. It still is an issue because we mediate primarily for families. It's probably always been at least 50% of our mediation caseload. And occasionally, but not always, we do experience clients who have been engaged in some form of domestic or intimate partner violence. And we need to know how to deal with that. And so this is kind of moving into application, how do we work with domestic violence within a particular process that we use? And I think it has implications not just for those of us who practice mediation, which there are probably few of you in the audience, but it has implications for anyone who serves other people. It has implications for lawyers who are going to be practicing family law, because you can't be so confident to believe that just because they have a lawyer, you don't have to worry about it anymore, that you can somehow protect them. That's absolutely false. This has implications for people who practice social work, people who practice therapy, law enforcement, etc. And so I'm hoping that you find those implications useful in your own practice. The first thing that I wanted to do was to define the two things in the way that we teach. We teach mediators at our center and around the country, sometimes in other countries. And what mediation really is, it's really a process for people. It's very unique. It's a process for people to sit down together and to figure out what they need to do to move on. So I'm going to just talk about this in the family mediation context. So people come to us in what we call family mediation. They're typically custody issues, visitation issues, or they're getting a full divorce. As you know, many couples have kids today who aren't married and have never been married. So they're coming together to try to keep the decisions in their own hands, to have conversations in a different way that allows them to hear each other and make the best decisions for their family. It's unique in that it provides party with this opportunity to own their own stuff and to work through it and make their best decisions. Unlike some other processes where you have a third party making the decision for you, or people pressuring you to do what they think is right or giving you advice that may or may not fit your situation. It's unique in that way. It's also a client-centered process. So it's the client's goals that guide the discussion. What should happen in ethical practice of mediation is that my need to have a settlement and to say my settlement rates are so fantastic should be secondary, if not at the bottom of the list. It's a client-centered process. The client's goals, what they want to talk about, what they need to have a productive conversation, and what they'd like the outcome to be should drive the process. So another aspect that makes it unique is that it's decision-focused. Some people go to mediation and they feel like it was similar to couples therapy, but it's not therapeutic. Mediators don't ask, how do you feel? Let's get at the root cause of these emotions, that sort of thing. It's decision-focused. So it's for people who come and they need to make some decisions that are probably pretty important. It could affect their lives and the lives of their dependents or others within their family. What sets it apart are three keys. The primary one is self-determination, and this really sets it apart from other alternative dispute options, such as just simple negotiation or having your attorneys negotiate for you, or arbitration, which is a third-party decision-making process. Self-determination is what really sets it apart. primarily, because what that tells you is that this is what we're supposed to be doing, is helping the parties to understand that these decisions are in their hands and to support party capacity to make decisions as best we can. We can't supplant their wisdom, their knowledge, their ability, but we need to recognize at every moment where there's an opportunity for them to exercise self-determination. So I'm sure as you've been listening to presentations on domestic violence so far, you're starting to think, I hope, that, gee, I wonder how self-determination works when someone's been a victim of domestic violence. The second key is impartiality. Mediators have to be neutral. That means that the offering advice has to be very limited. To say things like, I'm not sure if that would really fly in the courtroom if you brought this agreement. This isn't like it might be considered fair or balanced in terms of what you're deciding here, is about as far as you can go. You can't give advice. You can't sides. Makes it also challenging if people are experiencing any form of abuse or violence or have a lack of power at the table. And the third key is confidentiality. Unlike the other processes that we use, especially in court annexed types of cases, mediation is the only one that's confidential. And it's good on one hand because it speaks to the integrity of the process. It allows people to feel free to say what they need to say and not have it held against them later in a court proceeding. So if somebody makes an apology or makes an admission in a mediation that hasn't been made outside of mediation, they can't go to court and say, well, you admit this mediation. They can't call a mediator to testify. They can't get the mediator's notes. It's akin to a privilege in terms of confidentiality. Start to think about what the implications might be where domestic violence is concerned. Confidentiality could be a plus and could be a minus, because if things happen at the table that are subtle, that the mediator maybe doesn't notice because they don't have adequate training in what to recognize in terms of the signs of violence or other sorts of abuses, they could be hidden in the process or embedded in the process. Or alternatively, if something violent could happen and there's not laws in the state or one doesn't feel compelled to report those things for just general human ethics, confidentiality could endanger somebody potentially. In our state and in most states, mediators are considered to be held to the same standard as social workers, attorneys, and other helping professionals, where if there's any threats of violence to self or other, or even property, depending on the state, that it's an exception to mediation confidentiality. And so we can report those things. And in fact, we're expected to do something about it on the spot. And we'll talk about that today. So self-determination, I'm focusing there because this is really where it's at in terms of how we manage domestic violence or how we work with domestic violence. It's the capacity to make decisions that are voluntary, uncoerced, freely made, in consideration of client capacity, safe for everybody. Those aren't things that I as a person, as a human being, can guarantee. So we can't guarantee those things, but we make sure that clients know that this is what this process is to be used for people who feel they can do these things. Can you make a voluntary decision that's uncoerced? We want to make sure that we're avoiding undue influence, any sort of coercion, any threats against person, property, dependents, pets, those kinds of things that typically come up in domestic violence. And the thing about it is that people don't willingly say that. If we ask them, is there any threat of this? They all say, no, no, no. That would never happen. We don't have to worry about that, at least not at mediation, you know. And it's our job to read between the lines when we hear those kinds of things. But self-determination is important. It speaks to capacity. So moving into now definitions of domestic violence. There's some things to consider. You've heard a story. You've seen some of the laws that are being written. How do we define domestic violence? And it's defined using different language. This is the language I chose for today. Domestic violence is non-reciprocal. It's not this situation where you have a particularly conflicted couple who are pushing each other around, and it goes back and forth. It's not a reciprocal activity when we're talking. That is a form of violence. Yes, it's definitely a form of violence, just as verbal abuse is. But we're talking about a type that is non-reciprocal. It's cyclical. It starts with a buildup of tension, leads to a violent incident, followed by a period of calm and remorse. Kind of mimics the story we heard this morning. Repeats at greater frequency and severity, is ultimately lethal if the cycle is unbroken. So we're talking about something that's pretty significant here, and it's unique. You may be relating to some of these experiences. You may have been, as a teenager at some point, or seen a sibling or a cousin or some relative get into relationships where there was some shades of violence. They'd get drunk and push each other around, and then they eventually broke up. But you didn't have these other pieces going on. You didn't have after the violent incidents, you didn't have this calm and remorse. You just got more of the sort of heated back and forth, I hate you, sort of thing. You don't have the repetition. You don't have the lethality. So, and I'll let you know why that's important in a few minutes. So what's important to me as a mediator, as I'm training mediators, as I mediate family cases or supervise the mediation of family cases, I'm looking at how violence prevents the exercise of self-determination. And that's what I'm thinking about the entire time when I'm meeting with somebody separately is, what has the relationship been like, and can they exercise self-determination without fear? In terms of the batterer, their intent is to control and dominate the person. Again, that story that we heard this morning clearly illustrated that. If it wasn't about absolute control, I don't know what it was about. And so when we're thinking about, we're hearing a possible victim that's in my head. Is this a possible victim? I'm not sure. You start asking questions to determine, is the person that she's with right now, that she has kids with, because that's the triggering aspect for the Family Pilot Project, is there an intent to control or dominate the other person? Do they use abusive tactics to intimidate or threaten the victim into compliance? And these are subtle things that happen early in the relationship and escalate as time goes by. Typically, batterer intent includes a sense of entitlement. Again, you deserve it. You don't do anything right, until the victim quite quickly believes that is in fact the case. It's often triggered by a victim's attempt to assert independence or to disagree with the perpetrator. And violence escalates in severity and frequency. And I think I heard a little bit of this from one of the two speakers, I can't remember right now. But when is the likelihood of violence the greatest for a victim who's been involved in a pattern of domestic violence? Anybody know? Separates. Mediation in family and divorce cases is all about separation. So the fact that they're even required to go to mediation or choosing mediation, or she's invited him to mediation, raises the possibility of separation immediately. Sorry for the lightness of that, I'm not sure why. So these are some other characteristics. As you listen to them, and I'll tell you about some of the questions that we ask, we talk about who's in charge of the household, who seems to be sort of the decision maker. Batterer characteristics, this could fit an older couple, certainly. I heard a presentation yesterday at a leadership series where a woman my age was talking about her mom, who still signs her checks, Mrs. Robert Volk, right? There are different cultural, generational issues where that might be a normal thing, that the male is the head of the household. And it doesn't mean that that person's involved in domestic violence immediately. But when we start to add each of these up, another is that they begin to objectify the person. They call them names or have other ways of objectifying them. They're selfish. Their gain is someone else's loss. Everything is about them. Every argument turns to how it's all about them, and they're the one who's being victimized, and they're somehow being hurt by the person that they're battering. There's little or no consequences for their actions. They don't take steps if they've been arrested and had to go through steps, and I know you're going to hear about this in one of the next sessions. There's little or no sort of incentive or internal desire to do different. They refuse to take responsibility for their behavior, can be jealous and possessive. Their public and private behavior is very different. What you see in the public might be a very affectionate relationship, and in the home, a very violent relationship. One of the reasons why we get to screening, we don't recommend that you meet with couples together and do your pre-mediation meetings with them together, because they're public, that's how they're going to show their public behavior, not their private behavior. And you're more than likely going to get very soft responses from the victim and a different kind of response from the other. So, and I also wanted to highlight the cycle of violence, the wheel, because it remains an important symbol, I think, in the domestic violence and understanding domestic violence. And I've seen another opposite wheel that is the opposite of this, and how healthy relationships should work, and it's a really great illustration. And I've seen CVIC and other organizations using this in the schools to teach kids what healthy relationships are about, and I think it has real relevance. And it's something that we teach our mediators, because it's important to recognize that how in all of the multiple spokes on this wheel are impacted by domestic violence. Using coercion and threats, intimidation, emotional abuse. Emotional abuse is enough. Say that it's not until physical acts start to happen is another one of those stereotypes that is still pretty prevalent, I think, in people's thoughts and minds. Using isolation, not allowing them to have contact with their family or friends, finding fault with family members and friends and picking them apart until pretty soon she has no friends left at all, right? Making sure she stays at home, that whole, in all the freaky movies about domestic violence, we see the calling constantly, checking where they are, having access to phone records and text messages and all that sort of thing as part of isolation. Minimizing, denying, blaming the victim or other people on why it's happening or what's happened. Use of children, pets, etc. Using their privilege, which may include education, economic privilege, physical size as privilege. Using economic abuse, making sure that she only has so much money and has to ask for money or gets in trouble, emotional abuse or physical abuse for spending money on things like groceries or clothing for kids, etc. So all of these are examples of power and control and touch on physical violence, emotional violence, and sexual violence. So a few more things that I think are important to talk about before we move into screening. Some causes and misconceptions of domestic violence. And one is that intimate partner violence is a choice. It's learned through observation, family, friends, school, media. It's learned in culture and society. It's learned through experience and reinforcement. So people aren't born batterers. It's a learned behavior. Domestic violence is not caused by alcohol or drugs. One doesn't become abusive, and that's not an excuse for domestic violence. It's not caused by the relationship or the victim. It's not triggered by a person. It's not caused by sheer anger or stress. That would be very situational violence. And it's not caused by the batterer being out of control. But these are the things that we still hear all the time. These are the defenses that come up against domestic violence when someone's being accused of perpetrating that. The question is, how do we make it safe? We know we can't guarantee safety. Nobody can guarantee safety. The police can't guarantee safety. You can have 5 protection orders against somebody, and it's not a guarantee of safety. Nobody can have a police at their home 24/7. We can't tell people, and we used to in the mediation field, and some of you may have done this in your fields of study. You can't make an environment safe. You don't know if the building will start on fire. You can't guarantee safety. And guaranteeing safety isn't wise because it allows people to put their guard down. And in domestic violence situations, putting your guard down isn't an option. It's not a good idea. So what's important to recognize here? How do we make it safe? One is to recognize who has the expertise. And it's not us. The only person who's an expert in terms of their own experience of violence between them and another person is that person themselves. So the person who's telling you that they've experienced violence is the expert, and what they tell you they need, you need to listen to that. It's important that we listen to that. Strategies that we use to help to support their safety in mediation might be, well, first and foremost is pre-mediation. Anybody who is doing family mediation and does not conduct pre-mediation orientations is not screening properly for domestic violence. You can't just start when they come together for the first time. We tell people that ad nauseum. Domestic violence is required to be covered in every 40-hour mediation seminar. We have to spend 6 hours on it, which means 4 hours of instruction and 2 hours in a role play situation where they use the screening, and then we go into mediation, and there's signals and signs, and you practice exit planning and all of that sort of thing. And then mediators go out, and people in my profession of law are the worst violators of this rule, because somehow you get into practice and you're practicing family mediation and you think that maybe if I just keep them in separate rooms it won't matter. But it does matter because of the question that you answered just a few minutes ago, which is when it's most dangerous for the victim is when they're going to separate. So to tell yourself that if you just keep them in 2 different rooms, which by the way you're not mediating then anyway, you're negotiating, you're doing facilitated negotiations. It's not mediation. And you empower her to speak her voice. You go and deliver that message to him. He knows she said it. Like, we're not fooling anybody here. Not only that, we're putting her in a very dangerous situation by making her think that she can speak freely when she's been in a situation of violence in the past. So it's not an answer to separate them. So pre-mediation is critical. We need to be creating strategies within the mediation process itself. We need to be paying attention to anything that goes on post-mediation. To be honest, we don't have a lot to do with parties post-mediation unless there's going to be a second session, which oftentimes in family mediation you need 2, 3, even 4 sessions to complete of 3 hours about a piece to complete a full divorce or even to iron out most of the custody and property issues. We need to know what services exist in our community in case somebody's never accessed services and we recognize that suddenly we have a situation that involves domestic violence, and we need to know how to make referrals. Again, separate rooms do not equate to safety. Perpetuating violence. So next is this issue of screening tools. And when you're using a screening tool, there's some well-used ones. The one that we use is from Ohio, and it's not new. It's been around for a while. It's been tweaked and changed and improved on. But it's pretty solid and it's pretty lengthy. And what we do is we know it like the back of our hands. We internalize it so that we can be in conversation with somebody, whether it's male or female, and use those questions in a more conversational tone. Because if you take out a list and start going one by one with a victim, for example, it's going to feel very intimidating. It's going to feel, where is this going? They're not going to let me use mediation. I better answer this the right way. And so you've got to take into context that it needs to be conversational, and it's got to build trust between you and the other person. And our intent in using such a tool and to screen is to ascertain the intent of their partner's use of violence. What is the meaning of the violence to the person you're talking to? getting at some of those things. What is the effect of the acts of violence, whether it's emotional or otherwise, on the individual? And how does this fit with previous patterns of behavior? So that's sort of the context. Those are the things that we're looking for, that we're listening for. So how does the screening work? It starts, in all family cases, it should start at the beginning. Somebody calls us and says, I gotta go to mediation. It starts immediately. It's a family case. We get their names, we get their contact information, and right away we're listening for things like, do I have to be in the same room with that person? And we immediately say, no, you don't. We want to meet with you one-on-one first, and then you'll make decisions whether or not you can do that as the time goes. So it starts right at the beginning in the initial phone call. Asking if they have concerns, check if they have advocates, do they have an attorney, do they have other advocates that they work with? Could sound like a very benign question, gets information to you. Yes, I have an advocate from the Community Violence Center. Right away you know that there's going to be some differences in this case than in the case that didn't involve that. Pre-mediation intake or orientation is what comes next. It's a separate meeting with both parties, and our purpose are twofold. One is to make sure that they understand the process and how to use the process to their best ability. So letting them know that they make the decisions, they can bring their attorney, they can get information and bring it to the table, and what the mediators don't do. They don't give legal advice. This isn't a therapy session. They're there to support their conversation, help them make decisions. Those meetings are always done separately. In fact, we do them separately in all cases, because another purpose in that is to allow them to tell their story and to have someone listen to them the way that we listen, where it's basically just reflective listening. To have them think about how do they say what they need to say at the table. What are the ground rules or guidelines that they need to have in place? They sometimes get some clarity about their situation and become more articulate, because as we reflect back, they might think back to themselves, well, that's not exactly how it happened. It was really like this. So it's a chance for them to get more clear about their situation and come more ready to negotiate with the other person at the table or to the other person. As much as possible, it's done face-to-face. We're a rural state, so sometimes we need to use phone or Skype. Skype is better because it's like face-to-face. If technology is working. If it's by phone, it makes it very difficult. And if we have any red flags at all, we'll find a way to have the face-to-face, a second orientation meeting with a client. A lot of open-ended questions, and we'll use that screening tool if possible. And so the screening tool, these are some of the questions that come up with the screening tool. We're really inquiring without saying these words: control, coercion, intimidation, and fear. Because again, like any process that's available to people, we don't want to deny people the use of this process. We know what court does to families, right? We know how expensive it is. We know how divisive it is. Almost all families report after going through family litigation that their relationship with the other parent is worse than ever before, and their relationship with their kids has been damaged significantly. Not only that, any college savings, whatever, is gone, completely gone. It's not to say that litigation has to happen in family cases sometimes, because it certainly does. But mediation allows for them to co-parent much more peacefully, much more productively going forward. So people want the opportunity, regardless of what their capacity is at the time. So we ask the questions in a different way, like how are and were decisions made in your marriage or relationship? That gets at some of those control issues, financial control, and they'll start talking, and it's our job to listen and say, okay, you mentioned that, you don't have any access to the finances. How does that work? And what happens when you do need money? And have you ever gotten in trouble when you've spent too much money? And you listen for those sub-questions to emerge. What happens when you speak your mind and express your point of view? What happens when you and the other party fight or are angry with each other? What does that look like? Could you see that happening in the mediation room? No, this never happens in public. Again, it's a bit of a little signal that we get as mediators, whether or not, as we're making the determination, whether or not we should go forward with mediation. If some of the indicators are there, we might ask, what's the worst fight you've ever had? What did it look like? What happened? What's the most recent fight you've ever had? What happened? Kids there? Were there other people there? Have the police been called? Has the other party ever prevented you or tried to prevent you from being in contact with your family members or close friends? That typically will come up. Has the other party ever denied you access to money, food, shelter, clothes, needs for the children? Has the other party ever threatened to hurt you or kill himself or kill you? Of course, at this point, we're already planning we won't be going forward with mediation in this case. Have any concerns about sitting in the same room mediating with them? This is oftentimes the first question that we ask. What are your concerns about sitting person and working through these together? We probably already know something about how they make decisions, that maybe one person makes all the decisions. Could you sit in the same room if your advocate was with you? That make a difference for you might be a question that you ask. And these are not easy questions to ask. One of the reasons that we have our mediators role play, the pre-mediation orientation, is that you find out firsthand how hard it is to ask somebody this, and even in just a role play. We know it's not real, and yet we're sitting there and we're like, they have the checklist and they're asking them in a rote way, just one after the other, which is not how you should do it, but it's a way to begin the training process. And it's so uncomfortable to ask these questions of somebody. It feels personal and it feels private, right? Which again is one of the reasons, in my opinion, why domestic violence continues at shockingly high numbers, is because we all are like, okay, I kind of know my friend over there is getting slapped around by her boyfriend, but I don't really want to say anything because it's private. So these questions are difficult to ask. We learn them, we integrate them, and we start putting them in softly. And not just because it's hard to ask, but because if we don't do it that way, it sends red flags for the person who really wants to be able to mediate and not go to court, because maybe they've been to court before, and there were severe repercussions from going to court. So we want to get good information. We want to build trust. We want the answers to be truthful and real, and not sugar-coated, not trying to hide something. And it's really our job when all of a sudden we feel her pulling back and not answering the questions openly, that we note that. I feel like you've kind of pulled back and that you're not really, I'm not sure if you're feeling like you're afraid to answer these questions or what's going on for you. And we check in and ask for that information. We want to make sure that we are not putting anybody in a situation where lethality is risky. And some of the lethality questions were covered in a light way in the last list, but are more direct here. The seriously injure or kill, and why do you think that? The frequency and seriousness of intimidation, threats or assaults, frightening or worse incidents, weapons in the house, pets injured. Occasionally, it's happened at our center, not frequently, but occasionally, we have people who've never, ever seen anybody, not a therapist, not a counselor, not a domestic violence professional, nobody. And these questions have never been asked of them before. So how do you make the decision whether or not to mediate? You've got intimidation possibly coming up in your pre-mediation work, and it's on a big continuum of not intimidated at all to completely intimidated. And most of our clients aren't over here. Most of those clients get screened out occasionally. Maybe 1 in 10 years is over here. Most of them are over here in the first 50%. And at what point do we make the decision and take away self-determination? So it's sort of an ethical struggle for us, and say, no, I'm sorry, we're not willing to mediate. It's a tough decision. Obviously, if a party is in immediate danger, we make that decision really quickly, and our role changes from being a mediator to being somewhat of a mediator. I'll talk about that in a couple minutes on what we do. There's no apparent immediate danger, but the abused party disclosed violence by or fear of the other party. So this might be a situation where they maybe have kids together, they haven't lived together for many years. When they lived together, there was protection orders, there was violence, and now it's like 7 years later. She's still afraid of him, but there's been no incident for the last 5 years, right? Not easy to make decisions in these cases. There's nonviolent but abusive and controlling behavior, so maybe some emotional abuse. There's a protection order or restraining order in effect, you can't bring them to mediation. We will have judges, as recently as in 2012, call and say, well, I really want them to mediate. I'll make an exception to the restraining order so that you can mediate with them. And we're not very willing to accept that request by the judge. What we'll typically say is, well, we need to meet with them each separately and do screening before we're willing to do that. And if you're willing to have them sit together, why did you give them a protection order in the first place? You know, we can't protect that. The stereotypes still exist. So once we've made that determination, which is no black and white answer, okay, only if this, then no, if that, then yes. It's not like that. It's shades of gray that we're working with. And so we have to be really clear about this. Screening is an ongoing process. I've talked a lot about how we do that in the pre-mediation part of it, but we need to be alert and aware and looking for it all the time, because we might have gotten what seems to be a very high functioning, very respectful couple coming in pre-mediation orientations, then they get to the table and we see the dynamics completely flip on its head. And so we have to be watching for it at all times. What feels safe to a person in mediation is an important question to know. Signals between the client and the mediator in the event the client sees indicators. So in the case I was just talking about, where maybe 7 years ago they were living together, lots of violence. It's been 5 years. They've been kind of sharing visitation just fine. Now there needs to be a change, and she's got some fears. We might develop a signal, a recent signal and we ask them, what would your signal be? And her signal was she was going to ask for a Coke. That was her signal. And what that told the mediator was that the mediator would say, you know, I really need to take a quick break. I need to use the bathroom, and I'd like to talk with each of you separately just to see how it's going for you. And we meet with her immediately, check out what the signal was all about, where she was, make a determination there whether or not to continue, allow time for her to leave the building while we're meeting with him for as long as possible, and eventually just explaining to him that, you know, we recognize that we have a conflict of interest here, this isn't going to work. We're going to send you back to your attorneys to see what the next steps are. Okay, so that might be how that looks. But signals are important. If you have any fears at all, or if you want to give somebody who wants the opportunity to mediate and there's not been immediate violence or threats. Exit planning is another piece that before, during, and after, always the advice is to allow her to leave first so he can't be waiting for her in our parking lot and follow her or approach her in that sort of setting. And we use co-mediation for a couple of reasons. One is to protect against conflicts of interest, because in North Dakota there's no 6 degrees of separation, right? It's 1 or 2. So midway through you realize that your best friend's cousin is this husband or something like that. So one mediator can drop out. Another is for training and teaching purposes, but it serves a great purpose in cases where violence might come up or those kinds of issues, because one of us can go sit with him and keep him there while the other one does safety planning and moves her out. So you can kind of keep the other person's anxiety from going through the roof by separating like that. Helping them identify who to call and where to go for help, support availability. If this is the first time it's coming up, is midstream mediation after screening. These are all questions that you need to ask. Have you ever been to a shelter before? All of those questions you need. Another issue is mandatory reporting and confidentiality. Not all mediators are mandated reporters. It doesn't follow with our ethics, and we're not a licensed group of professionals. Some of us are licensed attorneys, licensed social workers, et cetera. And those licenses require us to be mandated reporters. And if you're going to be a mandated reporter at the mediation table, the only thing that you have to do is make sure that you list it as an exception to the rules of confidentiality, that you are consider yourself to be a mandated reporter. But note that not all mediators hold themselves out to be. Services that are important to be aware of in your community: the crisis line, the national hotline, your shelters and centers, what it means and what the processes are like, at least in a cursory way of getting protection and restraining orders, advocacy referrals, safety planning, all those things. So I wanted to just tell one story before I ended today. And that's a recent case that came to us. And there were a couple from a very small town, in North Dakota somewhere, southwest of here. And we had to do our pre-mediation work by phone because of the distance. Neither party could come to Grand Forks. And she right away disclosed that there had been some violence, but she really wanted to mediate, and she wasn't afraid of him anymore. And he's moved on and has a new girlfriend, and yada, yada, right? So my coworker, Sarah, had taken that call and done the orientation and then met with him and got some red flags from him. And I don't remember exactly what, but some of the comments that he made about her as a parent, about her capacity, was a little bit surprising to her. So she called the woman back and said, I have some concerns. I'm just not sure. Would it be possible for me to talk to your attorney? And she said, sure. So she called the attorney, and the attorney shared similar concerns, that even though this woman was sort of denying that there was ongoing violence or threats or fear, she was a little afraid of this. And so Sarah said, well, I'm going to come out there. I'm going to drive out there then and meet with her in person. I need to see her in person. So met with her in person, got a little more information, but still there was a lot of, no, I can do this. I really want to do this. I don't want to go to court. Court is bad. Why do you think court would be bad? I don't know. I just hear that from my friends. That's about all she would say. So it's getting closer. They set a date for mediation, and all Sarah kept telling me is, I don't feel good about this. It doesn't feel good in my gut. I really don't want to do this. And I said, then we're not doing it. Because in some situations, especially in this type of situation, I think our gut instincts are right on most of the time. And so she took a deep breath, called up this woman and said, I'm not comfortable going forward with mediation. I'm really sorry. Maybe another mediator would take this, but I think you should go back to your attorney and have your attorneys work through this instead. And this woman started crying and breathed this huge sigh of relief and said, thank you for not going forward with this. What are you going to tell him? I'm so afraid if he knows. He said we're mediating, period. And if he finds out that I'm the one who said no to mediation, I'm going to be in trouble. So talked with her right then, got her attorney on the phone in a 3-way call, and talked about safety planning and that sort of thing. And then our typical script in calling someone is that we realize that we have a conflict of interest, some ethical concerns. We can't be the mediators in this case, so we'll have to send it back to your attorneys, and we're very sorry. And he didn't really ask any questions. He said, well, why is that? And Sarah just said, well, I realize that I know some of your family members, and I just don't feel comfortable because I would see them after this. He asked for names, and she said, I don't feel comfortable giving names. I didn't give names to your ex-wife either. So I'll just leave it at that. So it was sort of a really good case for us to use in training as well, because it tells you that these things are subtle. Nobody wants to be denied the opportunity to go through a process like mediation or whatever it is. And they don't want to be feeling like they're incapacitated, that they want to feel like they're capable. And so when they're faced with threats of violence or that sort of thing, they're not going to be able to be operating from their sense of strength and capacity. They're operating from fear entirely, and any agreements that they reach aren't going to be the kind of agreement I want to support in a process like mediation. So If you find yourself practicing mediation or being involved in that process, hopefully you know a little bit more about how important that is to protect against domestic violence and how keeping them in separate rooms doesn't do, that's just ignoring the problem or pretending like it doesn't exist. And then I don't think I'd feel like I'd clean hands afterwards if something bad happened. And I hope you wouldn't either. So any questions that you have about domestic violence and mediation process? Yeah.
While of them doing the research, of them doing the work, have you ever had mediated a case of domestic violence that was previously domestic violence?
There have been a couple of times where we mediated where people had been in a violent relationship, but the degree and the distance between them had been so great that it wasn't really an issue anymore. And we try to remedy some of that stuff by having attorneys present at the table or advocates, or have her talk to her old advocate or things like that. But we want to be really careful that about that and continue to screen for that, I think. So it's just an ongoing concern, and it's in a couple other states they have programs. One is in upstate New York, and I have a colleague there who has a really wonderful program where the Conflict Resolution Center and the Domestic Violence Center aren't prohibited from working together. In our state and in other states they are, by a grant that doesn't allow the Domestic Violence Center to even utter the words mediation. But they're not prohibited by that. And so the domestic violence advocates screen the case, all their family cases for them. And they're better trained than I am, for sure. And they screen the cases, and the cases that are clear come to mediation. The cases that are gray, they might find ways to remedy them. That might include some counseling and therapy that happens before you go to mediation. And in cases where there is violence, they occasionally will mediate with advocates in the room if she's in a shelter, or they'll mediate actually in the separate rooms, but they'll have an advocate in both rooms and a mediator in both rooms to allow them to negotiate, and then they'll have all the safety plans in place. And so it's sort of an interesting program. I'll mention it in the article that I'm writing, because it's a model of cooperation that allows that to happen. So any other questions?
I'm just wondering, I think the law in North Dakota now is that if you're getting a divorce, if you have a child custody issue, you have to go through mediation. So what is their alternative if you find that there is domestic violence in the relationship and you cannot mediate, but the law says you must mediate this issue? What do you do?
Well, the Family Pilot Project requires anyone who's has disputes around child custody or visitation to mediate. It mandates mediation. However, it requires screening for domestic violence. If there's a protection order, it's immediately removed from the pilot project and back into litigation. And if a mediator discovers domestic violence, there's no questions asked. It's just, in the case that I described that Sarah had, that was a family pilot project, and she called the administrator, who actually used to work for CAUSE, I think, and the Council on Abused Women's Services in Bismarck, and she said, if you're not comfortable, we'll just move it out. And it actually doesn't go to another mediator, even though we say that language in the conflict of interest language to the other party. She takes it out of the program and tells the judge that there's too much domestic violence in this particular case, and we're not accepting it. So. There's an out. Right?
I actually have a question too.
Okay.
What would you recommend to an attorney that is representing the abuser, and the abuser is saying he wants to go to mediation? Does that attorney have the right, or is he mandated to tell the mediation specialist, like, I'm not sure, but I suspect that he is abusive in this relationship?
Well, that's an interesting question, isn't it? There's the duty to represent your client, that is going to butt heads with that duty to sort of do the right thing, which I don't think is in the ethics code. However, it's something that we feel pressure around, and I think it would be a really interesting, I'm sure it's happened before, but for someone who's taken on a client, recognizes that they've abused the other spouse and be working in a proactive way with the other side to reduce and eliminate the likelihood of violence instead of just advocating for what they want in terms of custody, money, property, etc. I think in a collaborative law sort of process that would be more acceptable, but it creates legal challenges, ethical challenges for attorneys to sort of be advocating for what their client wants and at the same time and managing that abusive situation. It's tough.
Are there any other questions? Well, this time I'd like to thank Kristine for coming and speaking to us today. We really appreciate having her.
Thank you.